What's your name?
Mhm.
Name's Damien Amara.
Perfect.
Yeah,
to
all
hear
good.
that.
Pleased to meet you.
I'm about to
Very
give
pleasure.
Felix. Philip, are you talking to someone?
My name
Tell
is
your name, Abby.
Shu.
Yeah. Philippe's right next to us.
Oh, okay.
Yeah.
So tell Philip I say hi, and we're going to
Ah,
take this.
don't worry, I hear that. No, you can hear me, Henry?
No, he can't.
Oh, he can. Okay, but you say him hi from a part 2.
Tell him what?
Say hi to him.
Philippe says hi.
Oh, okay. All right. Let's go.
Hi, good.
Jesus, a lot of people on roads today.
Oh, hip
for
hop.
fuck's sake, hip hop.
Good lord. Can't catch a break.
Over your saddle.
Really? People over there. Do you see all them?
I do.
Is he still there? Felix, do you see Damien? Where'd he go? He was just there before I lost my head.
Yeah, I don't see him now.
He might be in that telegram station. Did you
I
just
just
look
checked in
there?
there. It is quite dusty.
Did you check his estate?
No, I haven't, but I thought he was sticking around here.
Hi, sir.
He might be.
Mhm.
Maybe we get
Yeah,
rid of
don't
some of
worry,
these
of
horses.
course.
It'll show.
Remember your name?
I was gonna try to,
Yeah.
dupe
Yeah, I
him into coming
remember.
to his
Yeah,
with me.
why am I gonna need chocolate? Of course, I'm gonna buy it from you directly.
It's alright. You ready to head out?
Yeah. Thanks so much
Indeed.
for. Yeah, I feel
Horse.
like
Spins
on
around
one
like
of your
dumb.
Hi,
employees.
Felix.
And
Let's
yeah, give me
steal one of
everything
these
I need.
horses.
Very
Not
Oh,
sorry,
steal,
wait,
like,
no,
sorry.
not the middle one.
speak to
Not the
you,
middle
I
one,
didn't
that's
speak
mine.
to you when,
No, I'm not gonna take that one. What about this
we
Kentucky
conclude the
Sailor?
thing.
Who do you think owns this?
That is
I'll borrow it.
Perfect.
And then you
Very
get
glad
to
to
the
see you again.
things.
I,
Can't catch a break.
Well, it's probably good that we didn't stay in roads.
Yeah, I mean, all the head pops that are happening over there. Wasn't happening too much until past hour or so.
Well, to that bank robbery, right?
Yeah, pretty much right after it started happening.
All right. Well, it's been a while since I've been here. Is this all new? These tents and things?
Oh yeah, they are. Look at that. Okay.
A wagon? No wheels? All right. Let's try to. I don't know where his office would be, so maybe we just go in one of these rooms.
I believe it's upstairs if I remember correctly.
All right. God damn it, Damien. All right. I don't know what he expected us to do here. That's all right. There should be a. What is this couch thing? What about that table in the corner? Does that work? Right. Okay. Felix, how are you as far as what could be covered? Is that all good?
Yes.
Okay. This test pretty much is going to cover your understanding of that course. It might add in a few additional pieces, but other than what was covered, the rest is kind of going to be up to you.
Okay.
This test is not going to cover anything extensive like that. If you wish to continue your education, of course, read any books we have in the library or find one of us and ask us questions.
Okay.
So let's turn to the State of Monroe Penal Code. Do you have a copy of that?
Yes, sir.
Okay. Let's run to Article 4. And let's look at the first portion of this, Article 4. It says, the right of the people to be secure in their persons, houses, and effects against unreasonable searches and seizures shall not be violated. In your interpretation of this, what does unreasonable mean?
So, based off of what we talked about in class, an unreasonable search and seizure is something that does not it does not have enough evidence. It doesn't have probable cause or what's
Mm-hmm.
yeah,
Yeah, that's
Hello.
probable
fine.
cause.
I'm on it.
Oh, sorry. Y'all
When-
can go inside if you want and go up
Well,
onto the
the doors
balcony.
were locked, so Damien said we could go in his office, and then we come out here, and all the doors are locked.
Yeah, I know. I'm sorry. I was off shooting rabbits. Come on, come on, come on.
Oh,
I'm gonna
okay.
open the doors for y'all.
Oh, thank you.
You can use the library or the office, whatever you'd like. Yeah, like my gun. Say yes.
Nice and pretty.
It goes well with your shirt.
Thank you very much. Library's right here if you'd like to use it.
Oh, perfect. Yeah, this will work
Uh-huh.
great. Thanks, my name.
Nice and quiet, of course. You guys want any tea or anything? I got tea and sandwiches.
I'm okay, thank you, though, Monet.
You sure? What about you, Lucky?
I'm good. I go into people's houses and they ask me if I want things, and it makes me feel uncomfortable and strange.
Oh, all right.
That's a personality flaw. That's a character flaw.
That's all right. I'll just tell you to go suck a dick. Bye-bye.
I'm on it. All right. So, where were we? Oh, yes. Unreasonable seizure.
So yeah, it would basically be whether it be your personal effects, your home or business, without probable cause or without proper evidence, they cannot search that person's premises or property.
And what makes good evidence in your. Well, you said proper evidence, I think. Or did you say good evidence? I forgot. But what does that look like?
So proper evidence would be something like you couldn't use somebody's statement per se. It could allow you to be around the area, but unless you like personally witness something, upon following that lead, you can't actually go into or search somebody based off of that. It would come down to um, shoot, yeah, you'd have to actually witness it yourself. That would give you probable cause, but a statement only gives you reasonable suspicion. Reasonable suspicion, if I'm not mistaken.
Okay. So if we move to the second part of the article, where it asks for probable cause for a warrant to be issued, what types of evidence do you think can be used to support a warrant?
Think of multiple scenarios here.
Mm-hmm. Yep.
So I do know that if you have multiple witnesses that are stating the same thing, that does give you more of a more ground to stand on when it comes to a warrant. It allows you because everybody is giving you the same piece of evidence. I'm not sure if it has to be people from different groups or different towns, but the more statements that you have, the more justification it gives you for your warrant. So there's that. Of course, any eyewitness statement or any eyewitnesses from government. Um, any kind of linking piece of evidence to a crime that may be committed in an area, such as if say, if there was jewelry that was stolen from that location, and you can identify that jewelry as coming from that location.
Mm-hmm. Okay. Um, so at least in Monroe, the standard for probable cause is not that high. The As far as we are concerned with warrants, as long as there is a witness, at least one, and they are able to write an affidavit, basically a signed witness statement, as to what they've seen, that's enough to establish probable cause for a warrant.
Okay. I don't think we actually covered that.
What you were talking about is pretty much all the pieces you would need to prove in a courtroom beyond reasonable doubt that the crime happened.
Gotcha.
But as far as the initial warrant for arrest goes, the bar is not that high.
Okay.
If I had to explain probable cause, it would be 30 to 40%, maybe even 50% chance that the crime actually happened and this is the person who did it.
Okay.
Okay, so let's move on to Article 6, which describes due process but gives no explanation of what that is. Can you explain to me with how you interpret Article 6? What does due process mean?
So nobody should be deprived of their life, and their freedom, or their personal effects without going through the courts system, without having been. Uh, so it's different if, for instance, if somebody is witnessed committing first degree murder by a law officer, they can make an arrest there because they have sufficient evidence, and that's what the penal code allows. But as far as if it was a statement given by somebody, they would have to go through the court system uh, with a arrest warrant given, and they would have to actually take it to trial. Well, even whenever an officer makes an arrest at the same time, they still have to go to trial after that. They have a initial arrest period, and then they can bail out or wait until their trial, and then they go through their court case and determine the guilty or non-guilty verdict of the situation, but they should not be deprived of life, freedom, or property without going through that process.
Yeah, that's exactly right. Um, we set up a court system, and there are certain rules to make sure that innocent people aren't sent to jail. And in order to protect, well, in order to make sure people aren't going outside the lines of those rules, this amendment is in place. All it says is uh, basically uh, innocent until proven guilty. And there's certain process to proving that, and if it's not followed, it's a violation of this right, which is exactly what you said. Um, let's go to one more. Let's go to Article 10. And I don't know if y'all covered this in the class, so let me know if you didn't, because it's okay if you didn't. I'm just going to ask the question anyway. Do you know what the writ of habeas corpus is?
I don't think that was something we really in depth covered in class.
So it kind of ties in with due process, but the writ of habeas corpus is something that if you have a client being held in jail, you can apply for, you can petition the courts for. And basically, all it means is if the court grants it, the accused has to show up in front of a judge. The prosecution has to come with, and the prosecution has to explain why this person is being held. And if they don't have a good explanation, then that person can go free.
Okay.
It's basically a protection against people being held in jail cells without evidence. So I guess it also ties in with Article 4. All right. So that's enough of the Constitution. If we run over to the Penal Code,
Okay.
did y'all go through this whole entire thing?
I have read through this entire thing at least two or
Okay.
three times.
All right. Well, then I won't spend too much time on it. And I ask everybody this question because a lot of lawmen have trouble with it. And so if our defense lawyers know about it, maybe they can educate them a little bit. But can you read over the attempted second-degree murder charge and over the aggravated battery charge and let me know what the difference is?
Said attempted second degree.
No one's dying. It's just two different charges. For bodily injury, I guess.
So are you talking about the maximum punishment or
Sorry, let me rephrase this question. If you're a prosecutor or if you see an indictment come down from the Attorney General's office and you see one of these charges on there, how would you determine which? Well, okay, let's say you're in the Attorney General's office and you have some evidence in front of you. How would you decide which of these two charges to apply?
So one of them actually specifies the unlawful killing. So um, whenever it comes to aggravated battery only shows that there's a means to harm another individual by means of either potentially deadly weapons such as firearm, bow, or blade. Whereas second degree murder is more of actually having intent to end somebody's life while uh, presenting as an immediate danger and has no regard for human life. They have intent to actually kill the person rather than just harm or maim them.
Yep, that's perfect. That's exactly what we're looking for. Intent. That's if say it, if the prosecutor's office comes and charges either of these murder um, crimes, they have to prove intent. And especially with first degree murder, not only do they have to prove intent, they have to prove planned intent.
Now, that's got to be interesting because, they'd have to, I guess, hear something verbal or find some kind of written piece of evidence to actually uh, demonstrate, or maybe through their actions, like if they were trying to get after that person for a long time.
Mm-hmm. So they might get a search warrant for the person's Telegram records for a certain period of time.
Mhm.
Um, they might ask people that they talk to. Um, they might try to look at their business transactions. Maybe they bought a gun recently, or a a hatchet that they have no use for. Maybe they don't cut wood at all. They just bought a hatchet one day, and a couple days later, the victim has a big old slice through their neck or something. Something like that.
Mhm.
Just to try to tie it in. As a defender, your job is not to worry about any of that. Your job is to say, well, maybe he bought a hatchet because uh, he's got some trees in his yard that are, in danger of falling on his house. Something like that.
Mhm.
But yes, intent, especially for these big charges, is the main delineator between them. Same idea with the difference between torture and mayhem, because if you go to mayhem, it says depriving someone of their body part, but you can also say cutting off someone's finger is probably some form of torture. So again, there you have to have some level of intent for the higher charge.
Yeah, we were actually having a discussion earlier. I was listening to one of the LSO talk to one of the recruits about attempted murder versus um, what do you call it again, versus mayhem. Like if you would even apply mayhem in a situation where somebody threw a stick of dynamite and it ended up dismembering them. So they were like, that the mayhem might not stick in court. They may end up appealing that charge and having it removed. Uh,
Uh, it's likely in that case because when that person threw dynamite, did they intend for their body parts to fall off, or did they intend to kill them?
okay, so again, it's the intent.
Yes, and again that's the theme for a lot of these charges.
Okay.
Because there's always two parts to a crime. There's the uh, formation of the thought in the head, and then there's the action that comes out of that. And you do have to prove both pieces.
Mhm.
Okay, so that covers the Penal Code and the Constitution. I think you got pretty good grasp on both of those. Not a problem. Um, Now we'll just run through a few scenarios. Say Mr. Brown is in Valentine. He was caught after a bank robbery on his horse, and he's called you down to represent him. And my question to you is, how are you going to go about forming a defense?
So when you say he was caught on a horse after a bank robbery,
Hmm.
was this did the did the officers actually see him leave the bank robbery? Did
Right? Good question.
because you say they just found him, so that doesn't give me context as to what happened before they found him. There's a gap in between the bank robbery there, so I need to know exactly what happened between those 2 points.
Hmm.
Because then you run into linking them or how they're linked together. So based on that, as well as getting statements from him as to what happened. If there's anybody who can provide an alibi for his whereabouts during that time period, and let me think, if there was a if it was a situation, of course, I would have to get evidence from the law office as well to make sure to see what evidence and statements that they have um, about that situation in case if it was just somebody witnessed him, if it was the officers or law that witnessed him, and then see if it was just something as a matter of misidentification, such as maybe he was wearing similar clothing. So it really comes down to seeing what evidence is there uh, to work with to figure out where I go from that point.
Yeah, that's perfect. That's exactly what we're looking for. Let me look at bank robbery. I think is bank robbery an appeal charge? Let me look. Sorry, don't. It is a okay. So it's an appeal charge. So um, doesn't matter what you say. The New Hanover deputies are being stubborn. They're going to charge him with bank robbery anyway. So once you know that, and you realize that it's an appeal only charge, so they're sending him off to Sisika, and you
Could I
telegram him. Oh, go ahead.
could I uh, file a motion about habeas corpus under that and demand to see the evidence that they have before they send or ship them off to Cisco?
Um, it's a good question. If if it was me, no. Habeas corpus is when they're holding someone. Well, they would have to turn over their evidence to you anyway.
Mm-hmm.
Um, if they're not, that's different than habeas. That's just a problem in general. um, Habeas corpus is when somebody's being held without a, without proper evidence that they've done the crime.
So,
So yeah,
so it's
it's
only when
definitely.
you can prove that you uh, bring habeas corpus in.
You don't have to prove it, but you have to have. You don't even have to, but it's good when you. So you're applying for a writ from the courts, and basically that petition has to say, "Hey, this is my client. This is what he was arrested for, and this is why I believe he probably shouldn't be held."
So is that after he's been arrested and put in Sisika and is awaiting trial?
Mm-hmm. Exactly. It's when
Ah,
he's.
I see what you're saying.
It's basically when you think he's being held illegally in detention.
Okay.
So in this case, when it's an appeal only charge, I, I like it. I think that's pretty creative. Um, but at the same time, it's only 100 days. I
Yeah.
just want to wait for him to get out and appeal it on the backside.
Yeah, because I imagine a writ for habeas corpus probably takes time to get done. So.
It does take time because it takes one of us judges. It takes a prosecutor or a, uh, I guess if the lawmen want to do it, they can come, and then it takes the defendant and his lawyer to show up as well. So there's quite a few people that have to be arranged for. But let's say okay, so you have gone there. They're saying, right, Mr. Whitaker, that we understand your argument. However, these are appeal only charges, so we're sending them to Sisika for 100 days. And you see him the next day, and he wants to appeal, and he agrees on the price that you are charging for that appeal, or I guess an initial. Um, Jesus, I can't even remember the word right now.
Consultation.
Yeah, consultation, but he. What the hell's it called when you give someone an estimate? An estimate. Jesus. You lay out an initial estimate and say, okay, these are my usual rates. I expect it to take this many hours, but it might take more, it might take less. Actually, don't say less. It might take more, so the price might go up a little bit. So you work that out, and how would you go from that point?
And we're talking about the bank robbery, right?
Mm-hmm.
So at that point, I go ahead and file for a motion for discovery. That way, I can extend the amount of time that I have to and look into his case. And then the pieces of evidence that or the stuff that I talked about earlier, collecting evidence from the sheriff's office as well as any eyewitnesses, and then getting his testimony as well or statement, and then anybody um, who can provide an alibi for him, find out what clothing he was wearing that day. Uh, if if he used a weapon and say if it was discharged um, during the um, during the bank robbery, and the officers did not check to see if his weapon was hot or cold when they found him, I would I would actually use that as evidence as well to kind of uh, in that instance it would be discrediting because it would show that there was negligence in their duties of ascertaining evidence to the scene.
Mm-hmm. Perfect. So you're casting doubt, which is your job as a defense attorney. Yeah, that's perfect. So you'll file the motion for discovery, and then it's um, one of us judges should see that motion in the filing cabinet and reach out to the attorney general's office to file that discovery. So then it rests on them to get it to you. And once that happens, everybody should be pretty much on the same page as far as the facts of the case go.
Okay.
Um, once everybody's got everybody's, uh, well, currently the defense does not have to file any of their evidence until we're in the courtroom. I, I don't know how long that will last, but right now, if you collect your own evidence, you don't have to submit that until right as the trial starts.
I kind of feel like that's kind of a scummy thing to do, honestly.
Yeah, it is.
But at the same time, you're talking about somebody's life you're fighting for.
Exactly. Um, so you have your discovery. Let's say the attorney generals get back with what they have, and now the ball passes back to you. And do you know what you need to do next?
So I get back the evidence, and I would go through every piece of evidence and basically try to pick apart whether it's something that's like a hearsay statement. It could be that I have evidence that proves what they're providing is inaccurate, or basically vindicates my client in any way. I would file for a motion to dismiss of the pieces of the case that I'm shooting holes in, essentially. Um,
Okay.
Trying to knock out as much evidence as possible before the trial.
Um, you definitely go for that. Generally, we like those issues worked out in the courtroom.
Mm-hmm.
Um, the the last piece of paper you have to file before going to trial is the appeal itself,
Okay.
and it's basically an explanation to the court about, based on the evidence that you have, um, why, well, just the basis for your client's appeal, and it can just be as simple as, well, he's been charged with robbing the bank on this day, um, but I actually have somebody here with somebody saying he was with him all day hunting up in Amberino. Or it can be as complex as, well, here's the state's evidence, and here's every single point that I have to refute it, and I believe this is a good basis for appeal. And it doesn't have to be a big document. You can write it straight on the filing cabinet, maybe just a very simple thing. Uh, you could say, based on the evidence the state has provided, the defense believes that it has a strong case for appeal and would like a trial set. You could even go that way. From there, it proceeds just like a normal criminal case. The judge on the case will try to schedule as best as they can um, a, a trial, and it's one of the hardest parts of this job is trying to get a time and a day when most of the important people to the case can show up. And then, yeah, then you'll be in the courtroom. I'm not sure how much Isaac went over what happens in there.
Mm, I recall. I don't believe he went into great detail.
Okay. Um, Generally, the court case goes, it will open, the charges will be read against the defendant, and they will be asked how they plead to each individual charge. After those pleadings are done, the case will open from the Attorney General's office explaining why they're there and what they're about to prove. And then you, as a defense lawyer, are going to get up there right after them and give a speech of your own about why your client is innocent. And so that's kind of your opening salvo from your battleships. And after that, you go into combat. Basically, the state will call their witnesses up to the stand. They will directly examine them. They will say, were you here on this day? Did you see the Valentine Bank this day? What was going on at the Valentine Bank? You know, things like that. And then after every single, or after each individual witness, you will have the opportunity to go up there and say, and cross-examine them, asking them questions to try and cast doubt on their testimony. Are you familiar with direct and cross-examination?
Yes, sir.
Okay, well then I won't go too much more into it. After all the state has produced all of their witnesses, you will have a chance, if you have any, to produce your own witnesses, direct examine them. State cross examines in return, and um, from there you go to closing statements. That middle portion is a little more complicated because you can introduce documents while you have a witness on the stand. You can introduce objects, and you can also introduce expert witnesses. the useful thing about expert witnesses is that they're not necessarily witnesses to the crime, but they are witnesses to their professional experience, and you can show them evidence and you can ask them questions about the evidence, and they can give their opinion. Regular witnesses cannot give their opinions. Does that all track so far?
Yeah, trying to think. So whenever a witness is calling or is giving an opinion, what type of objection do you give out? What is that called? Oh.
Just oh shit.
All right. What was I saying?
Yes, that was. I wish Isaac had spent time on it because it actually is. The process is important, but I just don't want y'all to get ambushed in there. It's called improper lay witness opinion. You would just be objection opinion.
Okay.
Um, and frankly, that's both the regular witnesses and expert witnesses. If they bring in an expert witness, say it's a doctor, and he starts giving opinions about wagon wheels or guns or anything like that, you can call him out on that too.
So expert witnesses are only allowed to call an opinion on something that is a subject matter in what they work or in their work field.
Exactly. And not only that, but if you do call in an expert witness of your own, you have to establish what kind of expert they are.
Okay.
For instance, if I called, let's say, Dr. Zora up to the stand, she's the head of the OBGYN specialty. I would begin by presenting to the court. I would say, this is Arzuli Zora. She's a expert witness. She's a doctor with the, well, I wouldn't testify for her. I would ask you these questions. I'd say, Ms. Zora, how long have you been a doctor? What kind of work have you done? Do you specialize in anything? How long have you specialized in it? How many babies have you delivered? You know, things like that. Just establishing her expertise. And then once you've established it, you can launch into your questions that you need an opinion about. But if she strays outside of that and she starts giving opinions on other things, then you can start launching objections against her. Does that all track?
It does. I'm just waiting for my opportunity to say objection here, say 5 times in 5 minutes.
Well, good. Yes, hearsay gets thrown out a lot. Then, and the real problem with hearsay is there's about 20 exceptions to the rule.
Hmm.
But it's okay. Object as much as you want. Object as much as you want. There's no penalty for it. You might get told to cool it a little bit on him, but there's no doesn't hurt your case to object. Um. Okay. So yeah, after you finish the middle period, you've introduced all the evidence you want, all the testimony you want, and you've cross-examined the same from the state. Then you just wrap up with little. Well, it can be little or large. Usually, I like to keep them kind of short. But you basically summarize the case and say why your client is still innocent. And that pretty much closes it out as far as your part in it is concerned. Um,
It's like Huckabee said, "Tell me what you're gonna say it. Now tell me what you said."
that's exactly right. It's an extremely good guidance on his part, and he's the one to give it because he's one of the best speakers I think I've ever come across in a court of law. Um, let me see if I don't think I have any other questions for you, Felix. You've done extremely well here, and I guess as far as I'm concerned, I'm happy to have you start defending people.
All right, I'm excited.
Do you have anything lined up that you know of?
No, I don't yet right now. So I'm going to go through a period of time where I'm going to basically be doing some research. I've actually been talking with Favish. Um,
Mm-hmm.
he told me about how he was given stuff for court cases prior to 1899 that can be used, such as the state of this versus this person. You know, it can be used to argue a case if it's close enough in similarity. So I'm going to be
Mm-hmm.
doing some research on that. Um,
Did he give you those resources, or do you need them?
he gave them to me,
All right, good, 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 good.
and we're actually talking about opening a firm together. So
Well, that's good to hear because Mr. Schimmel is an extremely good lawyer, as far as I can tell.
yeah, and I think me and him, if we put our heads together, we can accomplish a lot of things.
I think so too. That's good. I like that. That's what we want to hear. That's the whole point of doing this entire process, is to get people out there that want to do it. Not only that, but are resourceful and driven enough to figure a lot of things out for themselves.
Yeah, I mean that's kind of the thing about law from what I've seen. Every bit of it is about information. Every single bit of it. How you defend your client is by how much information and knowledge that you have. So that's why I'm taking time in the beginning to. I'm probably just going to be doing certifications and stuff like
Hmm.
marriage license and stuff like that. But
Right.
as far as like taking on cases, it's probably going to be a little bit before I dive into that.
Okay, that's all right. I know Favish is taking on a few, so um, I'm sure you could use some help in the background.
Yeah, I mean that's another way that I could approach it is kind of be his consultation, or somebody he can consult with and throw ideas back and forth. And what's kind of
Yeah, I
beautiful
agree.
is that he's more of European stars and I'm more of U.S. stars, so we can cover both time zones.
Oh yeah, I didn't know Favish was European stars.
Mm-hmm.
Hmm. Okay, good, 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 good. It finally we have a law firm that's not in fucking Armadillo. Happy about that. Did Favish give you any? Well, you said he gave you all those resources.
Yes.
Okay. So, do you have the Hex v United States?
Let me double check. Um, Gotta look through my book to remember which page he's on. Okay, so I don't think so. Um, I just have a folder that he gave me for case texts and Supreme Justia.
Oh, okay. Um, I'll get you Hex v United States, but maybe this one would be more interesting given the discussion we just had. Hold on. Sorry. I seem to have.
Mm-hmm. Yeah. What's the name? Oh, he's taking a call. Oh.
Sorry, I'm trying to get you a good summary of this. A lot of these, you put them in, and it's just it gives you the full text, which is fine. But sometimes we like to save our brains. Anyway, I'll just send you Hex. That's fine. And um, just like to get your opinion on what the rule means in this case.
Okay. So, in this situation, it would seem they're stating that whether somebody was in the vicinity, building, or even in the immediate area of a murder that happened does not necessarily implicate that somebody is an accomplice to the crime. If there's no evidence to suggest that they participated in any way, shape, or form. And that could be, maybe they were held there against their will, or it was a situation that just happened right in front of them. It, what's that word called? When somebody, or when it's not a premeditated thing, and somebody, for instance, they get into a fight with each other, and one beats the hell out of the other until he's actually dead, and the other person doesn't even know how to react; they just freeze up. So it doesn't actually implicate that they are an accomplice in that crime, just that they were present.
Okay. And how would you use it to defend someone in Monroe?
So that would come down to their story as far as how they ended up uh, in that situation, whether they came there together with the other individual or they came separate. Because if they came separate, it indicates that they weren't per se they weren't coming together with an object or coming into the situation with an objective. Um,
Mm-hmm.
then you also have you would try to find any evidence that implicates whether they actually participated in the situation. Whether that be somebody saying that they, I don't know, did they throw a rock at them? Did they interfere in any way? You could also use a defense in the situation if there was a third person scenario and they witnessed them try to interfere in the situation, not on behalf of the offending party who killed the individual, but as in the opposite regard, where they were trying to interfere getting that person away. Um, Basically, uh, the story of how they ended up in that situation is going to be the biggest storyteller as to whether or not they had any intent in the situation to actually be involved as an accomplice.
Mm-hmm. Yeah, that's perfect, and it all comes back to intent, as usual. Um, yeah, if I was filing an appeal, and even if I was filing some sort of motion in a case like this for my client, um, I would reference uh, Hicks v. United States as part of my argument about why the charges should be dropped. I would say, here's the precedent from the court, and based on the facts that I've received during discovery, seems like the state has no evidence that my client had any intention to become an accomplice other than being in the same building. So, based on that, and based on this precedent that's already been set, I would motion to dismiss these charges. Something like that.
From my understanding, state just went through a course with that with them Italian fellas, didn't they?
That's exactly where this would have been used. And nobody referenced it, but Longstreet used the line of thinking because there was no evidence that 4 out of the 6 people with warrants in there actually aided or abetted in the kidnapping or alleged murder. Anyway, so yeah, that's how I explained it to Favish. How you can use some of these earlier precedents. You can also go, into the fictional novel of the future. And if you find a very good argument from the future, rip it off, put your name on it. Don't tell anyone where you took it from.
Okay. You see, this is why I like the whole idea of being a lawyer, is because it requires you to use a lot of your brain. You actually have to interpret things.
Oh, exactly. That's the I I'm training someone who used to be a doctor, and they're always looking for the right answers for certain situations. And I told them that I can't give you that. There is none. It's not like broken bone. Here's the procedure, because it's rarely that simple in the law. Anyway, Felix, did you have any more questions?
Mm, I don't think I do at the moment. But I definitely, if I have questions, I know exactly who I'm going to come to.
All right, perfect. Either me or Arthur when he's around. I know he's happy to answer them.
Oh,
No, I
what
haven't
what
just-
is Arthur's telegram?
It is AL. AL 3994.
kind of funny. Your telegram was so easy to remember, and I got it from Favish, and Favish didn't what do you call it? Oh, it's doing that funny. There it goes. Do I need to
There it goes.
store this somewhere in my bank, maybe?
You can store it in your bank. If you're planning on defending people, the the more often you go to the police
Evening,
station, the more
gentlemen.
evening, Damon. The more often they'll know your face. But I've had situations. Who was talking to me where they'd gone up to a deputy and said they were a lawyer and they were looking for some details on a case, and the deputy said, "Show me some identification," and they couldn't. So that's why I brought these licenses out.
Okay. So
I-
if I lose one of these, do I just come to you?
Mm-hmm. Yeah,
Okay.
sure. I can always make another copy of it. Not a problem. But yeah, you can store it in your bank, on your horse, in your wagon if it's got a lockbox. Because I don't really foresee any other situation you might need it other than identification to an officer.
Okay. I wonder. At the same time, carrying this thing around kind of makes me a little leery. Because what if I get robbed and some robber thinks, "Hey, this be cool to have," and they just go around representing themselves as me.
uh, yeah. Well, if you lose it, let me know. It's got a watermark on it, so I'll just change the watermark on the next one.
Okay.
Yeah, I I don't see arrest records are technically public, so I don't really see you getting too much pushback for asking for records. But in fact, I've seen it today where the officers weren't quite sure who it was, and I had to go up there and sort that out. So hopefully these pieces of paper help out.
Okay. Well, I definitely I appreciate you taking the time to do this, and especially on such short notice. I was very happy to get this done today.
Yeah, of course. Yeah, no, that's one of my main tasks right now is making sure all those paralegals Huckabee just trained can take the test when they want to.
Yeah, it's definitely gonna help because I mean, especially there were so many people that were frustrated with that case with Spade Litchfield. I know they were pissed
Yes.
off, and one of the things that Huckabee said was, "Well, we don't have enough lawyers right now," and I said, "You know what? That sounds like fun."
Well, and I'm glad you you